My name is Liz Davies. I'm a barrister specialising in housing law. I work a lot with Wendy, who's at Hackney Law Centre, and I am also involved in the Haldane Society of Socialist Lawyers. If you want to know more about them, we have our magazine here up at the front. First thing I want to say is I think this campaign is great. I'm really pleased that a number of different campaigns, because there can be too many campaigns on the same subject, as we all know, that a number of different campaigns have come together to form Benefit Justice, and I'm also really pleased that it's being supported by Unite and PCS, and as we heard this morning by the Bakers Union, because I think the involvement of trade unions, particularly the public sector trade unions, is going to be absolutely key. I don't think we're going to be able to defeat these cuts without the trade unions being on our side. Indeed, I don't think we're going to be able to defeat these cuts unless the trade unions actually start to raise their game and campaign in a much more high-profile way than they've been doing so far. In terms of legal challenges, I want to talk about two types of court procedure. The one is the high-profile judicial reviews, like the one that Denise has just been talking about. And then I also want to have a think about what's likely to happen as people face eviction because of the bedroom tax, and those cases will start coming in 2 or 3 months after April, I would have thought. And then see what we can do with it, and to what extent this is the poll tax Mark II, to what extent this is Cameron's poll tax. And I have to say, I think that's both a useful analogy, but equally an analogy that you cannot take too far and we have to be careful about. So those are the points I'm going to cover. Judicial review. Judicial review are the big, high-profile cases. They're brought in the High Court. They may end up in the upper tribunal, but they start off in the High Court, and they hit the headlines. They are brought on, as Denise said, points of law only. You cannot go to a High Court judge and say, this is wrong because it hits poor people. Or this is wrong because it is wrong. I mean, one wants to say that. One High Court judge about 15 years ago struck down the law penalising asylum seekers because he said it was against the law of common humanity. But he sort of stood out against most judges. You can't really do that, whatever the law of common humanity is. That's not a concept recognised by most lawyers. They don't have much of any of those concepts. So judicial review is very limited in itself. It's not about judges deciding facts. It can only be brought against public authorities, normally councils and central government. It cannot be brought against primary legislation, acts of Parliament. Parliament is sovereign. Judges do not have jurisdiction over Parliament. The most that judges can do about an act of Parliament, if they somehow think it's wrong, the most that judges can do about an act of Parliament is if they decide that it is incompatible with the Human Rights Act, then judges can say so. But even then, that doesn't make that act of Parliament unlawful. It is simply a message from the judiciary that Parliament should change that law. Parliament doesn't have to. So judicial review is very limited indeed. And you'll see that when I go through a couple of the cases that have hit the headlines and have been successful, but they haven't brought the coalition's government of cuts crashing down, and they're not going to. Burnip and Birmingham Council. Linda Burnip is one of the organisers of DPAC. Good on her. And she, her family, along with some other families where there were disabled children, brought a challenge to the implementation of housing benefit regulations, not about the bedroom tax. This was housing benefit rules a couple of years ago, heard in the High Court about a year ago. And the Burnip case was all about that if housing benefit is only paid for rooms that the council thinks a family should reasonably occupy, that doesn't take account of a disabled child's need for an extra room. So that case was successful. The High Court said that the housing benefit regulations hadn't thought about that point, and that not taking account of the need of disabled children was a breach of the Equality Act, which prevents discrimination on a number of grounds, including discrimination against people because they're disabled. So that's a good point. It's a very good point, and it made a difference to those families with disabled children who were having their housing benefit cut because they had what the council regarded as too many rooms, and now all those cases are being reconsidered by the council. That brought justice for those families in those positions, but it didn't obviously bring the housing benefit regulations come crashing down. Riley and Wilson, the Poundland case that was in all the newspapers last month in February, when Riley and Wilson won in the Court of Appeal, and that was a challenge to the forced labour, slave labour JSA scheme that Ian from the Bakers Union was talking about in relation to his son this morning. Both Cat Riley and Jamie Wilson were JSA claimants who were told that if they did not engage in voluntary labour, if they did not engage in unpaid labour, not voluntary labour, that's part of the point, unpaid labour, Kate Riley at Poundland, then they would lose their JSA. And Kate Riley's case gives very clear evidence of her, I think it was 6 weeks at Poundland, did not involve any training in any what's rather bizarrely called retail skills. It simply involved her sweeping the floor and shelf stacking and so on and so forth. All perfectly reasonable to do as a job, not perfectly reasonable to have to do to provide free labour for employers while the state is paying the JSA and at the risk of losing your JSA if you refuse to go on the scheme. That case was initially not really successful in the High Court where it was first brought. The judge found against Riley and Wilson on most of the points that they made, and they appealed to the Court of Appeal, and part of their appeal was that this was contrary to the European Convention of Human Rights. They said this is forced labour, like slave labour, because we are required to do it under threat of losing our benefit, and because the employers aren't paying us, we just carry on getting our benefit. That argument got absolutely nowhere with the judges in the Court of Appeal. What won, and of course because they won, then the case became front page news. What won was a very technical point, which was that the regulations, the JSA regulations, which the DWP was using in order to say the regulations themselves provided for the sanction if you refused to go off and work in Poundland, and that those regulations had not been properly authorised under the primary legislation, the Act of Parliament, the Job Seekers Allowance Act 2005, I think it was, which gave permission to the Secretary of State to make regulations, but that these regulations had gone further than the permission required by the Act of Parliament. Very technical legal point, the sorts of things that Denise was talking about, you want to say this is wrong and this is against human rights, and you end up with, well, the secondary legislation wasn't properly delegated by the primary legislation, and that's how they won in the Court of Appeal. Great to win. That evening, the day that the Court of Appeal judgment was announced, Ian Duncan Smith laid new regulations, which obviously had been pored over by lawyers, in the hope that they were compatible with the Act of Parliament giving him the power to lay those regulations. He laid those new regulations before Parliament, and those new regulations have now come into law. Kate Riley, Jamie Wilson's lawyers are poring over those new regulations to see if they could take another clever legal point over it, because there is nothing wrong with this sort of skirmishing, troublemaking, trying to tie the government down in court. But that's what it is. Now, again, this case achieves a certain amount of justice for people who, at the same time as Kate Riley and Jamie Wilson were being required to go on these schemes, similar people who were required to go on these schemes didn't do so, lost their benefit as a result. They will get some backdated benefit from that for a few weeks. Again, so that's a bit of justice for those individual people, but it's not going to stop the DWP sending people off to work in Poundland. So we have to be very clear about what the limitations of these JRs can be. Wendy says there's been a judicial review issued against the bedroom tax. It's likely to be heard fairly soon, although I would have thought not before the bedroom tax comes into operation on the 1st of April.
It's listed for next week.
Is it actually listed?
Yeah.
Okay. Anyway,
permission application.
The permission application.
Yeah, sorry to be.
But again, the lawyers are doing what they can, but they're not attacking the bedroom tax head on. They are not saying the bedroom tax in itself is unlawful, let alone immoral, because the judge will just say, what's that got to do with me? They can't even say the bedroom tax is unlawful, because the bedroom tax was decided by Parliament. Parliament is sovereign. So it's a very specific point that the bedroom tax cuts do not take account of the needs of disabled children. So if they win, that will be great, and again, that will produce some justice for families that have people with a disability in them and that are hit by the bedroom tax. But it's not going to bring the government down on its knees. There are all sorts of examples of judicial reviews that are not successful. And these types of judicial reviews that are political, really, even though they're dressed up as discrimination claims or what have you, most of them are unsuccessful. There are many, many cases challenging closures of libraries, swimming pools, advice centres, other local services funded by councils where the councils have decided to close them. A few are successful in that a judge will decide that the council's decision-making process did not take account of the needs of certain people who should be protected by discrimination law, whether they're disabled people, whether it's black and ethnic minorities. Sometimes there's a point about discrimination on the grounds of sex if more women use a particular service or what have you. So they might win on discrimination, they might win on the rules for fair consultation.